Welcome back. Attorney Andrew Bethel of Bethel Law, where we talk estate planning, finances, real estate, and taxes. Here with another Q&A video, only a couple weeks later, as promised, and not because we filmed that other one just 2 minutes ago. Actually, that's exactly why, but regardless, we have some rather interesting questions this time regarding whether you can keep a trust account open indefinitely and whether your aunt is entitled to that rental income from your dead parents' homes. Both of these are questions we have gotten variations of a lot in person, and both of which can and have sparked lengthy and extensive or expensive litigation, which I've seen firsthand, so hit the like button, subscribe, and let's dive in. First up is a question from our first Q&A video. My parents' trust has run its course. How long can I keep the trust open, and how can I benefit from it in the future? Can I keep it going to somehow benefit me in any way? These are the best types of questions to ask an attorney because I get to give the best answer. It depends. This all depends on the terms of the trust and the state with jurisdiction over the trust. Generally, a trust will have to end at some point and should not be held open longer than designed or intended to. Doing so carries administrative overhead that must be addressed. The trust may now have to file a tax return and pay taxes on any income not distributed to the beneficiary within that year. Additionally, if there is income and even where such has been distributed to the beneficiaries, the trust will need to file a tax return and send each beneficiary a Schedule K-1 to include on their own tax return. This is so that beneficiary can now pay whatever taxes are due on their personal return at their personal rate, rather than the trust paying a higher trust tax rate. Keeping the trust open means that the trustee is also on the hook for all their trustee duties, including the duty to account. Any and all beneficiaries would be entitled to an accounting of the trust each year along with trust records at any point in time upon reasonable request. Going further, if the trust does not have language specifying assets must remain in trust for a period of time, then any beneficiary due an inheritance can demand a distribution and back that demand up with say it with me now, a lawsuit. They would sue the trustee to force a distribution of the trust estate. And like I alluded to before, I've seen this exact scenario occur multiple times and blow up into litigation. I won't go into details, but I'm currently involved in the peripherals of a case where we have had an informal agreement not to distribute and waive accountings, only for a beneficiary to decide later that they wanted to pay out instead. Finally, if the concern is asset protection, then absent some language in the trust requiring assets to be held in trust for a period of time, creditors of beneficiaries may still be able to collect against the debtor beneficiary by collecting from their portion of the trust. In essence, pulling from that beneficiary's share of the inheritance even though their funds are still in the trust. Again, all this depends on the terms of the trust and the controlling law. It depends. The next question is interesting because you see it when people try to bury their heads in the sand when it comes to getting title straightened out on a deceased person's property. To summarize, the commenter's grandparents have both passed away many years ago. Both properties are still in their names, yet the aunt has been renting out one of the properties and maybe pocketing the income. Based on the limited facts on hand, the aunt should not really be renting the property out. It's creating a potential mess of a situation. Where is the income from the rent being reported? Who's paying the taxes on that income? Is the aunt keeping the rental income to herself or is she sharing it equally with her siblings? Who's paying the property taxes? The list goes on. Essentially, those properties being in the estate of the grandparents, or more precisely, the second grandparent to pass away. Probate needs to be done to transfer the properties to the heirs, with the most likely scenario being equal among their children. This means the aunt only has a partial interest, as one of the commenter's parents would also have an interest. Any rental income produced during this time would also be part of their estate and thus included in this distribution. Plus, if any of the commenter's aunts or uncles passes away, or even their parents, and the commenter is not an only child, then now we have more people with only fractions of an interest in real property, essentially requiring it to be sold, or else you're putting grandchildren on title for something small like 1/8 of an interest in the property. Without more detail, I would say this is a potentially very messy situation. Probate property within a reasonable time after someone's death. Don't stick renters in property where the title holders are all dead. If you take one lesson from the questions in today's videos, let it be this. When it comes to probate, trusts, and inheriting property, don't try to do your own thing and hope it works out. Set terms and conditions on your own estate. Don't try to set the terms and conditions on someone else's estate. It won't work and will only cause a problem. With that, I'm attorney Andrew Bethel. Drop a comment below with your questions. Who knows, maybe I'll answer it in a video in only 3 months' time rather than 12. Don't forget to like and subscribe and check out our other great videos. Stay informed, and I'll see you next time.